Hello, and welcome back to another empowering episode of Global Desi Women, where we share real conversations, real journey, and real wisdom. I'm your host, Arti Solanki, business coach, a real estate broker, and a proud Desi woman. And I'm here today with my amazing co host, Bhavna Ludra, a licensed and a family and marriage therapist. Today's topic is one that many of us overlook, but it's crucial. Will, trust, and legacy planning. That's our topic today. And we're honored to have our special guest with us, Reena Bhushan, a brilliant attorney who's here to help us understand why it's so important, especially for Indian women, to be informed and empowered about their finances and legal futures. So, whether you are just starting your career, raising a family, or thinking about retirement, this conversation is for you. So, grab a cup of chai and let's get the conversation started. Rena, thank you so much. We welcome you to Global Desi Women.
Thank you for having me. I'm honored. Excited to talk to a wonderful group of Desi women and really kind of just make the community more knowledgeable about estate planning.
Yeah, I mean, like, there's a lot of times we hear when it comes to will and estate planning, especially they see women, we're like, oh, we don't need it. My husband has it. So why do I need it? So let's have that let's begin with that conversation before we even start anything else.
One of the biggest misconceptions about estate planning is, oh, why do I need anything? Doesn't everything just pass to my spouse anyway, automatically? Well, the answer to that is no. So it's very important that you and your spouse both have the correct planning in place. If you want your home to transfer, if you want your bank accounts to transfer, if you want IRAs and different, retirement accounts to transfer. Those are all things that need to be planned for to ensure that you have the proper documentation in place indicating who you want those to pass to, like a will or a trust. And then also to make sure that, the accounts that you do have the proper beneficiary designations on them still. Have you filled that out? A lot of people haven't. All of these types of errors or oversights can lead to having to go through probate court when your loved ones pass to make sure that those assets pass legally. But, there's many ways to plan for it where there's no court intervention at all when someone passes.
Yeah.
And that's the goal.
Yeah, and the other misconception is that, oh, we're so young and we don't need one will right now. But I've heard stories about people having like young kids. And God forbid, if anything happens to you as a parent, what happens to that young kid? That kid is completely lost. They don't, there's family members don't know what to do, how to manage the situation, right? So can you talk a little bit about that?
Yeah, so first and foremost, if you have minor children, the most important part of your estate plan is going to be designating a custodian to care for them, right? If you are not there to do it yourself, if your spouse is not there to do it yourself, who is going to actually be taking care of them day to day? Another decision to make, and this person may not be the same as the one that cares for them on a day to day basis, but who is going to take care of their financials, right? That you are presumably going to be leaving them money. How does that get doled out? Are there going to be contingencies in place for, what those expenses can be used for? If you have a will only, you can designate that, that money can be held in a trust for minors for a certain amount of time. If you don't know how your children, you can never tell what your children are going to turn out to be or how they're going to be. You may want to create a trust so that you have the ultimate level of control as to how those funds are spread out throughout the lifetime of your child. Do you want to make sure that, they have enough for college and then, give them maybe disbursements after that, when they're 25? Do you want them to maybe you already know that they're not great with their finances, or maybe they have some sort of special need or substance abuse problem. All of these things are common. So, in that sense, you can create a trust that says, hey, I'm appointing this person to manage their financial affairs because I don't know if they can or not. If
Yeah.
you have a year old, you just don't know what the possibilities are.
Yeah.
What happens to you, it's going to be very important to try to figure out how much control you want over the money that you're going to be leaving them.
Right.
So I know I want to jump in because some people might not even understand, just like a layman's thing, what is will and what is trust.
Mm.
Because a lot of people are confused, if they haven't really, if they hear, it's like a foreign language to them.
No,
You know,
I
so
understand. It's-
so if I were to walk into your office, don't know anything, and if say, okay, I want to make a will. So, or then you say, how about trust? Then I'll be like, what is that? Trust? I trust you. So,
Well, that's a good
okay,
first start.
yeah. So just kind of put it in for just just simple
I
language.
a client that comes to my office, we do have to I have to do information gathering about, valuation of their estate, what their wishes are, who their heirs are, all of these types of things to determine, what the best plan would be for them, whether it's a will-based plan or a trust-based plan. Not everyone needs trusts. I feel like a lot of attorneys kind of just default to doing trust planning. But, if you have minimal assets, maybe, one home and a couple of bank accounts, and you don't have any minor children, a will would just be fine, right? But essentially, what a will does is it's a document that is submitted into the probate court here that effectively dictates who will manage your estate after you pass and who all of your assets will go to. A trust, on the other hand, gives you a lot more flexibility. If you plan with a will, everything is going to be public information. So a big a big portion of creating a trust is for privacy, but the main reason is essentially to just avoid probate court.
Yeah.
So, statute, anything that's placed in a trust is considered a non-probate asset, meaning that it doesn't fall under the jurisdiction of the probate court. A trust is considered to be a third-party agreement between you as the creator of the trust. The trustee is who you appoint to manage the trust. That's generally the spouses while they're alive. And then who is going to be the beneficiaries and how you dictate that. So the biggest reason that people do create trust is for probate avoidance, but it's not always necessary. But a will always is necessary. Even if you get a trust-based plan, you're always going to get a will. And we always also recommend long-term care planning
Yeah.
documents.
I was
So
just about to say that will also have they should always include the medical will along with it so that it helps.
So you estate planning is a pyramid, right? You have to build your base first. And the base for anyone, whether you have $5 to your name or $50 million to your name, is going to be a will and your long term care planning documents. So that in this day and age, people are living longer than ever, but we're not immune to long term diseases or, inflictions like dementia, Alzheimer's, anything like that, that where, you are alive, but you don't have legal capacity to make decisions on your behalf anymore, right? So in that situation, it's best to have your long term planning documents in place before something happens. Because if you already are incapacitated, it's too late to enter into those types of agreements. And your family will have to go to court to be appointed your guardian or to do things for you. So the most basic long-term care planning documents are probably good that people will recognize, and they are the most important are probably going to be your financial power of attorney. So if you become incapacitated, someone is there and has already been appointed to manage your financial affairs. And then your medical power of attorney, right? Who's going to make your medical decisions? That might not be the same person as your financial power of attorney, although generally it is just spouses, right? But, you want to designate alternatives, right? Who is alternatively going to make that decision or those decisions? Do you have one child that's more fiscally responsible that you might want to be your financial power of attorney? Do you have one, child or a family member that you think is more attuned to medical decision making? And if you don't have family, there's also always corporate trustees and corporate executors that you can appoint, which is even more important in that situation because you don't have family to rely on. So it's important for everybody to have at least those documents, will and long-term care planning. From
Yeah.
there, you build a pyramid for trusts, and then if you have estate tax consequences, then we go to irrevocable trusts, and we go, keep building up the pyramid.
So a quick one, when you say medical power of attorney, do they have to, let's say if somebody wants to just have a medical power of attorney, like whenever you go to the hospital, they ask you, do you have medical power of attorney? So can they just, they said that the hospital say, oh, you can just go online and get it printed and get it notarized, and that's all it takes. Is that as simple as that?
Not really as simple as that, just because the forms that you find online are inconsistent. They usually don't address everything that you would want. You want to make sure that it is specific to your state. You want to make sure that it has other provisions included in it, like HIPAA language. The medical power of attorneys nowadays, you also generally want them to include language for an advance directive, a living will, or another word for living will. Essentially, what would happen to you in like a terminal irreversible condition? What would you want to happen to you? That's essentially to provide guidance to your medical power of attorney and what you would want in those situations. The best example I can give is, the comatose patient. The spouse says, oh, she would never want to live like that. And her family says, oh, no, yes, she would. Let's keep her plugged in, right? You want to dictate to your medical power of attorney already what, just for peace of mind in making those decisions, put it on paper so they can feel comfortable with the decisions that they're making for you.
Yeah.
So yeah.
I was going to say that, and also people need to, I think there's a lot of myth about like, once you made the will, that's it. Like, it's not that. While you're living, while you're capable of changing anything you want, they can change it.
Well, yeah, there are plenty of times and opportunities in your life where you may want to revisit your will, right? And have it redrafted, revised. Perhaps you've grown out of a will based program or a will based plan, and now a trust based plan is going to be more effective for you to accomplish your goals. Marriage, divorce, children, special needs, something happens to someone. Someone gets a disability in your family, and you want to make sure they're taken care of. If you come into a lot of money, even if you lose quite a bit of money, you might want to simplify the current plan that you have now. I know a lot of clients will come back to adjust for grandchildren and make lifetime generation skipping trusts, so that, their trusts continue forever and ever so long as there's money and
Yeah.
every generation will get it. This is how our community builds generational wealth here in the US.
Yes, absolutely true. So, what is the biggest mistakes you see that the people make when they are planning their estate planning?
Biggest mistakes that people make is just not speaking to an estate planning attorney about what your options are. It's not a one size fits all kind of planning, right? There's
Yeah.
so many different options depending on what your wishes are. And your plan should be specifically tailored to your needs and your growth, right? And if you do have a small business, my office specializes in helping small business owners specifically with all of their needs, right? And estate planning being the first and foremost important one. Business succession planning. If your husband is 100% owner of his business, that doesn't automatically pass to you when he passes, right? The proper documentation needs to be in place. Is the company going to buy the spouse out? Are they going to shut down the business? Do you want to continue it? Is there a child that maybe wants to take over the business? How do you account for how the earnings from that business will, be inherited by your multiple children? There's so many things to think about in that sense as well.
So, since you mentioned this, so if the person is 100% owner of that business, and if he passes away, then the money, I understand that the money is froze, right? You can't get access to the money right away. It has to go to probate before, if he doesn't have a will.
That's correct. It does have to go to probate, but there's ways to plan for that so that it's automatically transfers. It's important for business owners to make sure that they have the correct company documents in place, buy sell agreements. We work a lot with creating family limited partnerships for family businesses because at the end of the day, they want to keep everything in house and the children end up acquiring minor shares while the parents are alive, and then that switches over at a later time. There's so many different ways to plan it, and it just really depends on how long you want the business to continue, what you want to happen. Do you want to sell it and have your spouse get a lump sum? Do you want what you really want to do is ensure that they are taken care of at the standard of living that they're accustomed to,
Yeah,
even after you pass. And if you're not there to run your business, they should know what to do in that situation.
yeah, absolutely, absolutely. So, how early do you think that someone should start planning their will or trust?
And I would suggest for even college students having a medical power of attorney and a financial power of attorney and your those types of documents in place is really important.
Mm,
Your parents aren't automatically allowed to make decisions for you if you're over the age of 18. So I've said it's important to start planning for your children right when they fly the coop.
Yeah, yeah, I guess. Yeah, it's and we don't really think about that, when
No.
kids are growing up, and then we really don't think until, as Indians, I think we don't start thinking about it until we're after 40 or 50, and then you're like, oh damn, we need a will or trust.
It's just important for people that are in their 20s and 30s that have assets. If you have your own home, if you have a condo, if you have any kind of real property, if you have a spouse, if you have children, any of these things. But then also just what's going to happen to your bank account. You worked hard for that money. You don't want your family to have to spend a significant amount in probate court to get it.
Yeah.
Any amount because the cost of a will is nominal compared to the protections that it does offer you, right? So it is worth revisiting your will maybe 2 or 3 times in your life. Start with a very simple will, and then from there, upgrade it as you need to. When you get married, when you have children, when your children are grown up again, maybe when you have grandchildren, if you've had a huge change in wealth one way or the other. If you've had to file for divorce is a big one. Blended families. If you have a blended family, it's very important. If you have someone in your family that you want to ensure is taken care of because they have special needs, that's also very important.
Yeah.
But like I said, trusts are very commonly used these days just to avoid probate.
Yeah. Yeah. So I was gonna ask something, but it kind of like
I can
it's
add.
go ahead.
Well, I'll give you a scenario.
So let me know if I'm rambling.
No, no,
You're
no. It's
making a lot of sense
yeah.
and making it everything so sound so simple. A lot of people think it's such a heavy burden and they don't want to deal with it. I think it's just an
There's
avoid.
any heavy lift for them. Your attorney should be doing heavy lifting for you. I mean, I don't consider myself to be an effective advisor if you don't understand what planning I'm doing for you. And in that sense, it is important to of course, I have clients that come in and just be like, I'll sign anything. It is important to kind of just get the nuts and bolts down. And I want to make sure that you understand what I'm doing for you.
Right.
And if you know how it works, then you're just better prepared.
Yeah.
Yeah. I want to ask you actually a scenario. I had one of my clients and her ex passed away and he didn't have any will and she had young children and his family stepped in and they wanted to take over all his assets. And it was such a long dragging battle because she couldn't get any I mean, what do you get monthly child support? It was also frozen because everything was just frozen because they came up with a will. that everything will go to his parents or sibling. So for her, she had to really fight for that, even child support. So, and then nothing, children was not going to get anything after he was
Wow.
passed. So he never really had a will, but the family came up with something, document. So it was, I don't know
Maybe he
exactly,
must have made it before he got married or
something.
something.
Yeah. So it was, of course, from Indian.
It was her ex, right? So they'd already been divorced.
Yes, they were already divorced.
Yeah,
Yes.
and the spouse has a lot less rights once you're divorced, right?
Minor, kids were minor. They were not beneficiary. I said kids were minor, so they were not beneficiary of anything. So everything went to his family, and she had to really fight to get just the child support. Mhm. Children were 7 and 4, so it was really hard for her. So I'm just saying that a lot of for women, since this we are talking about women, and for our Indian heritage, we don't really think
Think
about all
about it.
these
Yeah.
things. So even when going back, she said, yeah, there were a couple of times we talked about having a will. And he said if he had something, he would have put kids as a beneficiary. Forget me. I was, after that they got divorced. I would not get anything, but at least kids would have gotten something. So,
Yeah,
yeah, so that was really difficult because she didn't work. And then after the divorce, she was just doing very small part-time job. So it was very difficult.
child support to help her with the children, I'm sure.
So, so that's why I'm saying we are talking about women. So we want to be the advocate for that. That they
Hmm.
need to have those conversation in their own family. It's not something very pleasant for some people to bring it up.
I think
Yeah,
in a community, even the seniors, they get very irritated when the point will comes. They're like, I'm not going to die right now. Like, I don't want to make a will.
Yes, I had to bring it up with my parents, and I said, "You got to get this ready." Yes, and they were like, "What is this?"
every community though. The closer you are, the less, or the more in denial you are about it. But I have a lot of senior couples come into my office and the spouse, the wife doesn't know anything about your finances. Like doesn't know how to pay the bills, doesn't know which bills there are, doesn't know any of this stuff. So estate planning is I'm going to go over every single thing that you own, every single asset. How are we going to make sure it's fully funded into your trust or just to make sure it's taken care of, right? How is this going to pass through probate? Have we done beneficiary designations? We just want to make sure every single item is addressed. So it's a great time also or opportunity for you to, really get your family finances in order, which I don't think a lot of families have. So then in case something does happen to you, your spouse will know exactly how to, have that kind of continuity in life.
Yeah. Does that matter even if you have, like, say, these the savings account or the fidelity accounts, and on those accounts they have the beneficiary as their wife's name. But does that matter? Even though if there's a name as a beneficiary is written, they still need to have a will, right?
They still need to have a will because when you work with all of these different third parties, banks, brokerage accounts and things like that, they're constantly changing their rules. I've had some that have been easier for people to get access to bank accounts and funds because there was a payable on death beneficiary without having to go to court. I've had some, third party banks and things request that, you at least get in, some sort of affidavit of heirship, which means you need to open up a probate, right? So there are ways to ensure proper planning around that so it doesn't become an issue
Yeah.
and can ensure that you avoid probate.
Yeah.
But as these third party companies, I mean, they can do whatever they want, and they do routinely change their rules
Yeah.
and regulations. Years there is less risk that they want to take on, and so that does show up with your own rights.
Yeah. So when making will as a couple, they make a will together or they each have their individual will separate?
So there was a time when joint wills was kind of the standard, but that was a long time ago. Now, men and women both have their own assets, their own inheritance, their own properties, maybe their own separate kids, all kinds of differing interests. So, in that sense, they do have separate wills. It is, however, common still for a married couple to have a jointly planned trust.
Okay. So the
Mhm.
trust can be jointly,
And it
but
commonly
the
is.
will should be.
So long as, so long as both spouses' positions are aligned on what they want to happen to their estates. And it's common that, spouses want, hey, if something happens to me, I want everything to go to my spouse. If my spouse is predeceased me, I want everything to go to my children in whatever shares and
Yeah.
our ages. I want them to be able to get one third of their trust fund at this age, 25, then 30, then 35, the remaining balance or something like that. But that's common.
Yeah. Yeah. And even in trust, I guess when the trust and you have younger kids, you can appoint somebody to handle the trust account. They can be the trustee until the kid is 18 or 21, or how does it work?
So the Uniform Transfer to Minors Act is, I think, the age here is, well, for my wills, I usually put like it going into a contingent trust until the age of 25. But if you want control over the finances, so say maybe you have a large estate and you don't want to give your 25-year-old a large chunk of inheritance all at once. You want to make sure it lasts them. That's when trust planning would come into place because you can continue past that point so long as you have a trustee appointed. And even your kids can become a co-trustee of their own trust at some point, or they can manage their own trust, when they turn 40, 35, depending on how long you want it to last. It can last their entire lifetime if you want it to, and just pass directly to your grandchildren after that.
Wow. Amazing. Yeah, that's pretty, like, there's so many things you think about when making a will and trust that you don't really, it takes how long does it take for you? Like, say if a client comes in, I guess it would take a consultation to explain it to them what goes on and how everything goes on. And it also maybe depends on what they want, right? Like, or how they want to divide their asset to how many ever kids or their spouse or who they want to, or a dog or a cat or whatever they
I think the trusts are a thing.
Yeah.
I could see you maybe doing something like that. That needs, that needs to be taken care of in the future.
Yeah.
I forgot the question.
No, I was saying that how long does it take for you to, like, how long does it usually the consultation and everything last? Like, how much time a person should be prepared to spend with their attorney usually to get all the questions answered?
Do you like to meet everyone in person for their initial consultation? By then, I've already sent them information on services that I provide, pricing. Also, I've sent them, my estate planning questionnaires, business questionnaires, and that just really sets us up for the initial consultation for me not to have to do a bunch of fact finding. So and that
Mm,
gets you memory jog too, because if you just sit there and ask people like on the spot, they forgot their assets. You won't even believe it.
yeah.
So by the time you come in, what we'll do is talk about your assets, talk about what your wishes are, talk about what kind of legacy you want to leave behind. And then from there, I generally will send out or formulate, a letter containing my estate planning recommendations, what they are, and, of course, a fee agreement. I think most estate planning attorneys are making the switch to doing a flat fee billing rate per package or per whatever plan you want. And it's great. It's, very transparent. Clients aren't scared to call you and ask you questions. Yeah. I think that people really appreciate it. And if the estate planning attorneys aren't doing it yet, they will be. And then, so for a will based plan, I aim to finish the plan within 1 month. That would include, our initial consultation. Generally, we do a lot of back and forth by email to gather all of the data and information related to their assets, and their planning. That month time frame, I'll send out drafts for them to review, and then we usually set a time to go over those to make it that they understand what's going on in them and understand the function of each of the documents. And then they'll come into my office to finalize and execute and notarize the documents. So that usually takes about a month for a will-based plan. For a
Oh,
trust-based plan, the aim is 2 months. And for complex estate plans, and that's usually anything, where you have estate tax concerns, that can be from 3 to 6 months, depending on what all you need to get done.
yeah, that was going to be my next question. So I don't know if you can answer this, but if you have a trust, does that affect as you get older with your Medicare or Medicaid? Does that affect?
Yeah, so there are Medicaid asset planning trusts. They're completely different than a regular revocable living trust. So everything I've been talking about is the most common trust that most couples will use or families will use to avoid probate, and that's a revocable living trust. But that still counts as part of your assets for Medicaid planning, Medicare planning, all that kinds of stuff. So you would need to still try and find a way to spend down your estate in that sense. And there are specific trusts that will allow you to do that.
Mm.
So if you're getting to a certain age and you're living off Social Security, you plan on needing those types of programs in the future. Your planning would be different with me.
Okay. Yeah, that's what I was like, because having a trust and then like, yeah, you're gonna leave your legacy for the kids and grandkids, but what about you while you're living? You don't want to be paying for all the.
The beauty of a revocable living trust, while you're alive, while you and your spouse are alive, you are the beneficiaries of that trust, right?
Yeah.
You can use your assets as you wish. You can buy and sell your anything that's in it in the name of the trust, and it is yours. We'll transfer your bank accounts into your trust name. Will transfer your real property into your trust name. All of those things are to avoid probate, but you still have full control over them while you're alive.
Yeah. Yeah. So do you recommend talking about your will and trust with your kids while you're alive, or it should be like, okay, I just wanna. What is as an attorney, what do you think is a good idea or a good approach to do?
to avoid all the conflict.
Yeah. You don't want the kids fighting over after the death,
I
right?
mean, they're fighting while you're alive.
Right.
In your
Keep on
will,
fighting while you're alive.
in your trust, you're always going to be appointing someone to kind of manage those, right? So for your will, that person is called your executor. And for your trust, that person is called your trustee. Those people definitely should be aware of your planning, right? And you should talk to them about it. Ensure that, they're up for the task. You do have to, like, I do require, or it's best to require alternates for both of those roles, maybe two or three, depending on what your family dynamic is, in case one of them can't serve. But those people should surely know about your planning. Do they need to know all of the details of who's getting what and this right now? No, but they should know the gist of, hey, I created this will or trust. I would like you to manage it. Is that something that you would be willing to do? Right. The other part of it is, as far as what you're giving in your will or trust, or the substance of it, I think it really kind of depends on the age of your children. This is obviously probably going to go right over, a kid's head, right? They're not going to understand any of these concepts. And I mean, I don't know if you really want to put ideas of, their parents' mortality in their head either at that age. But if your kids are mature enough to understand, then I would definitely share with them what your thoughts are, especially when it comes to your medical power of attorney and your wishes in those situations,
Yeah.
right?
At least the person who's gonna pull the plug should know that that person is gonna do.
this, but then even with the financials, as far as what you're leaving to your children or to whatnot, I have families that come in that, do an unequal distribution of inheritance. It's something I would probably talk to your kids about first.
Yeah.
Um, please let them know because, leaving your other children to deal with after you passed away
Yeah. That
can be,
is not a good idea.
it will dispel like it'll make it more difficult or less likely of having any kind of dispute over your will or your trust that would also require probate, right? But yeah, I mean, generally, it's advisable if your children are older to at least let them know that you have a will, it exists, and it depends on the family too. My family is very open about, death. This is what I do for a living.
Yeah. Same. I mean, like we talk with the kids very openly about this too, and especially we had a good laugh at the medical will when we had that discussion come up. We had a very good laugh on that.
Have to be so serious. This is something that's going to affect everyone one day. And realistically, what you really need to do is make sure that these people that are important persons in your estate are just as aware as possible of what your wishes are. That's the best way to ensure that your wishes are carried out, right?
And it was, yeah, I think it was back then, like, the olden times where will used to be like so secretive and like, nobody knew in the family even that there was a will there or where it is or who has the document. And it just like, it was one of like the biggest, even we've seen that in movies, right? Like they make such a big scene about it, like, oh, there is a will.
Tell you that very often there is not a will reading. Invite everyone to a room in an attorney's office and they read it out in a that's that's not real life.
Yeah.
But, they don't have to be secretive. I think, it's open and honest is the best way to go about it. And that, ensures to your family members that you're actually getting something that they want from their estate. My dad has a collection of Persian rugs, and I told him, I was like, hey, I want those.
Well, yeah, I know. Kids will if they have a dip, this is mine and this is mine.
My sister is more into saris and, the Indian jewelry and things like that. And she told my mom, hey, I want these. And we were like, okay, fine. So it's kind of better to talk about it and just know because even if you do an even distribution of your estate, one third, like I have two other siblings, so one third, one third, one third, your trustees will still have to decide what portion of that one third they get. Right. So it's good to talk about it.
That is, I think that's the most open way and a good conversation you can have with your kids is to let them know up front the what you're gonna leave behind, right? Because I feel like it's at least for me, I felt like it's more comforting to know and have that conversation right when you're alive to see them okay, or even if they're arguing, then you see that okay, this person does not like this, or this kid does not like this, and so you can make those adjustments or you can plan your will or trust accordingly.
Or if you figure out that you have two kids and they're not going to agree on anything, perhaps the trustee needs to be, your sister or another family member, right? And they will be the tiebreaker between your children who are your actual beneficiary. Your trustee and your executor are not necessarily beneficiaries of your estate in any way. They have only chosen to manage your affairs. So it's not someone that you have to leave anything to.
Yeah. Yeah, that's true. And it's not necessary that you have to have a will and trust just for your spouse or for your kids. It could be somebody else too that you want to live something for them.
Yeah, so, on top of the common bequest, which is, everything to my spouse, and if my spouse has predeceased me, everything to my children in equal shares. One option that you have in your will or your trust is something called specific bequests. So if you have something and that comes right off the top, right? And then the remainder will go to your spouse or whoever, right? So say you have family somewhere that you feel could use some additional assistance monetarily. You want to leave them.
Times people can leave things for nonprofit organizations that they want to serve.
So too, you can leave things to charities, but for charities, if you plan on leaving something to charity, it is something worthwhile when you come into my office where we'll talk about the tax consequences of doing that during your lifetime versus doing it when you pass away. Because there's some tax incentives to trying to do it during your lifetime, maybe, creating a donor advised fund or some people come in and they want to create their own nonprofit. There's so many different options for that that will give you tax benefits now. That one we'll have a conversation about if that's what you want to end up doing for sure. Because there's quite a few ways that you can plan for charitable gifting.
Yeah.
You
Yeah,
can,
and I guess that makes sense because it's considered as a donation. So, like you said, it gives you tax benefit while you're alive rather than,
yeah.
unless you're leaving an estate or a property, then it's a different story.
Well, it depends. If it's a highly appreciating asset, then we try to leave it for estate, right? But if it's cash or something like that, you might want to just give it away during your lifetime. That might be
Yeah.
the way to do it. So it just kind of depends on what goals you want to accomplish with your charitable gifting as well. I mean, are you trying to plan for a legacy? Is this just an anonymous gift? How large is the fund going to be? Because in certain situations, it may be appropriate to even start like private foundations and, things of that nature. But that's generally something that I see a lot more with clients that have estate tax consequences and they're trying to bend down their estate to some point.
One thing I forgot to ask you is that a lot of times, I guess you hear this about the written wills.
Yeah, can I interrupt 1 second? Just, for the specific bequest, it doesn't have to be cash. You can say, "Hey, I leave my gold Rolex to my old business partner. Hey, I leave this piece of jewelry or this car or this whatever specifically to a person." I just wanna make that clear. It's not just about money.
Yeah.
Or you can
Okay.
give anything specifically to one person or to whoever.
And that goes right? Yeah, yeah.
That
Yeah.
goes in our trust.
You could have 10 pages. Will, like, I'm going sending this to this and giving it to, oh my goodness.
Yeah, but if you have, like, that many people that you wanna give, like, cash to, it's best to be as specific as possible. So, I want $20,000 to come out of my Chase bank account ending in so and so. But you have to keep in mind if that $20,000 isn't in your Chase account, that gift will never be made because it
Mm.
comes from another source. But, if you pass away and there's no money in your Chase account, maybe you didn't wanna make those distributions or bequests anymore.
I was just going to say that we forgot to ask us about handwritten wills. Are they still considered as a will? Or if they're not notarized, or if they're just handwritten by somebody saying that, okay, I'm writing this in so and so date and this is what I wish for. And does that still a legal document?
So, a written will is called a holographic will in Texas. They are valid. Texas allows for holographic wills, but at the same time, you still will need to go through probate and prove up that that will is what you say it is, right?
Mm.
So, is that really their signature? Are the bequests that are being made, is that in their handwriting? Is there another will that came after it that voids this one? And then they'll look at, yeah, I mean, it is valid, but it's a lot more work during the probate court. So if you go to probate court with a valid will, the judge is going to be like, "Oh, are you the executor? Is this will validly, attested?" Done and done. Okay, let's start making distributions, get an itemized inventory together. You would actually have to prove up a holographic will. And it would just be more steps to prove that that document is what it says.
Right. So the bottom line is, ladies, if you're listening to this podcast, please contact your attorney. contact Reena Bhushan, get advice and get your will done, because I think men and women really need to understand the importance of handling their finances even after their spouses are gone. You don't wait till that tight. You want to start understanding what your finances are. You need to start understanding how the bills are paid, or what assets do you have. Because a lot of women don't even know how much money they have in their bank account because their husband's taking care of everything.
And I mean, the biggest thing about it is that waiting until you need these documents is generally too late to go back and do them. So you've missed out on your opportunity for doing the simplified route.
Hmm.
So early planning is the best planning.
Yep. Yep. Absolutely. Absolutely. Rena, thank you so, so, so much for sharing your incredible knowledge and making this topic approachable and empowering. And we really appreciate your time and your knowledge, and giving us a very clear picture all about will and trust. So I hope our listeners really understand it and grasp it and apply it in their life. They get these legal documents done before it's too late. And to all our listeners, if today's conversation sparked something for you, don't wait. Taking charge of your legal and financial future is an act of love for yourself and your family. If you enjoyed this episode, please leave us a review. We really, really love hearing your feedback. So definitely review, because that also gives us it helps us bring you more empowering conversations. So we truly appreciate if you leave us a review and feedback. And I guess we would love to collaborate with businesses and organizations who aligned with our mission. So contact us if you want to have your advertisement on our podcast, or if you want us, or just want to know more about a podcast, just send us an email. Until next time, be kind to yourself and others, stay empowered and stay inspired. Thank you.
Thank you.